Copwatch. Important Copwatch applauds the city's decision to keep police misconduct appeal hearings public, but the current proposal has too many flaws to let it move forward. We strenuously object to the proposal to silence community input during hearings. CRC is not only capable of separating facts from opinions, but the existing ordinance directs them to hear any evidence offered, saying they must consider evidence only from the investigation when deciding on the findings. The city attorney admitted that the police association has never filed a grievance based on public comments at a CRC hearing. The community has the same case summary paperwork as the appellant and the officer. Does the city plan to prohibit those parties from speaking at the appeals too? The way the ordinance is written, CRC would have to call a special meeting to take public input and might be prohibited from taking input at their regular meetings. Public comment helps CRC on community context, policy, training, and their own protocols. The last case at CRC benefited from comments. After it was pointed out they were using an old directive, they changed their recommendation on taser use using the correct directive. Silencing the community will only lead to more disruptions rather than less. Meanwhile, breaking the 11-member panel into 3-person panels will create a number of problems. In terms of diversity, with the current committee of 7 women and 4 men, 4 persons of color, it's likely some panels will be all female and white. Copwatch suggests expanding CRC to 15 members and tapping into the 20-member Police Review Board civilian pool to round out 7-member panels, specifically with 4 CRC members and 3 PRB members with a quorum of 5. If one of the 3 CRC members becomes ill, the appeal will have to be delayed, leading to appeals taking much longer than the proposed 21 days. If CRC sends a case back for more investigation, the same 3 members will have to be available for the supplemental hearing, or else others have to read the case file and listen to a recording from the first hearing. In the last 2 years, CRC has met 16 times to consider just 8 appeals, in part because 3 cases were poorly investigated and 2 led to conference hearings. And the conference hearing provision to allow the chief to come back to CRC if he or she disagrees with their finding.
I'm going to grant each of these panelists some additional time because each of their organizations has put a lot of time into these issues. So go ahead, Dan.
I appreciate it, Mayor Hills. The conference hearing causes more unnecessary delays, and it should be removed, and disputed cases should go back to City Council. And we have other members of Copwatch who will round out my testimony. But I just want to say this point that was made about the Police Review Board and the CRC being duplicative. In our records of the last 20 appeals that were heard since that code change was implemented, we could only find 2 where the case was heard both at the Police Review Board and the CRC. So it's very rare that happens, and you can take steps we can discuss later about how to make it so that a case wouldn't end up going to both places.
Thank you.